Welcome to the Roetzel Health Law HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw HotSpot. I'm Ericka Adler, shareholder at Roetzel Health and leader of our healthcare practice group. Today, I'm joined with Mike Scotti, also a shareholder at Roetzel Health and leader of our litigation practice. Thanks for joining us, Mike.
Hey, happy to be here.
Today, we're going to talk about a topic that a lot of clients ask me about, which is the basics of contracts. What is a contract? Can a contract be oral or does it need to be in writing? How do you enforce a contract? And what do you do if you breach a contract? And I think these are some basic topics that lots of people think they understand, but sometimes have wrong or misunderstood notions about how contracts actually work. So why don't we start off by just talking about what a contract is and what it isn't, and what the difference is between a written and oral contract.
Sure. So contracts do come in two forms, as you just alluded to, written and oral. And to make a contract, you have to have an offer to perform some service or to buy something or to enter in some employment agreement. And then you have to have an acceptance of that offer. And there has to be consideration from the one providing the services to the one for the person that receives the services, providing consideration to the one that's providing the services. And once there's a meeting of a mind, then everybody agrees that what the terms of the deal are, you have a contract. And the vast majority of the times for medical practices, those contracts are in writing. And so the terms of the deal, each party's obligations, rights, and responsibilities are written down. But sometimes they're not written down. But those contracts can also be enforceable. But you have to have the same elements. You have to have an offer, acceptance, and consideration. So they come in both forms.
Right. And in healthcare, I mean, obviously there are some compliance reasons for contracts to be written, but we do sometimes see people working in an office, hygienists, for example, might be somebody without a written contract. And from time to time, we have independent contractors or employees who simply work with a contract or work with an expired contract. So what happens if you have a contract and you believe that somebody has breached that contract? And what would be the difference if it was oral versus if it was in writing?
Okay. So what happens if you think somebody had to breach the contract? First, I would recommend you contact a lawyer. And when you contact a lawyer, you have in your hand the terms of the contract you believe make up the contract, and then why you think it's been breached. And then you can look at it. And then if you do see a breach, many times the party who did the breaching has an opportunity to cure. So you'd send them a letter and you would simply say, listen, we believe you're in breach. This is the specific action or conduct you engaged in which caused the breach. And we're demanding that you cure it immediately, or we're going to take further action. And depending on what the breach is, that would define what the further action is. It's important to know that contracts are not self-enforcing, that contracts are really only worth what you're willing to pay to enforce them. Because it's not illegal to break a contract. It's not criminal. I mean, people are entitled to break contracts, and they do it on a regular basis, as many as a business decision. But when you break a contract, you're obligated to pay the other side for damages caused by your breach. And for example, if it's a service contract, say you have a contract with a vendor that provides you laboratory services or pharmacy services, and you decide to terminate that contract before you're allowed to, well, they can sue you for their damages. And what makes a damage? It's not the revenue you would have paid them. So you would have paid them $100,000 over 6 months. It's the actual lost profit that revenue would have generated. And then the party, and if you decide to breach a contract, the party you breached it with also has a duty to mitigate. So if they have employees that are displaced or capital machines that they have to put to a new location, they have an obligation to try to do that to limit their damages. And if they fail to attempt to mitigate their damages in any lawsuit or arbitration, that's a defense to mitigate any damages they may have suffered. So I guess to go over it, the first thing you do is you contact them through a lawyer, or at least after consulting a lawyer, and give somebody an opportunity to cure. If they didn't cure, then you have to make a decision. Do you file a lawsuit, or if you have an arbitration provision in your contract, do you make a demand for arbitration? And before you do that, you need to weigh the business risks of that and action, because legal fees in many situations are costlier than the damages caused by the breach, or at least very significant, have to be taken into account.
Right. And if you don't, I mean, if you have a termination provision, that's great, but often only one party has that termination provision with a right to cure, and other times it's silent. So what happens if you are supposed to be paid X amount of money and you're the employee, and you don't have a provision in your contract that says you can terminate if the employer breaches? Is it an automatic breach when somebody doesn't fulfill their obligations? And do you have to give them a right to cure if the contract doesn't provide for it?
Yeah, the answer to that is it depends. It depends on the contract, but generally, if there's not an obligation in the contract to give somebody a right to cure, you don't have to give them an opportunity to cure. You can terminate the contract and basically say, we're terminating the contract because of your breach. In other words, you forced us into this situation, and so we are breaking the contract, and that's a perfectly acceptable way to proceed, unless there's provisions in the contract which don't allow you to do that.
Right. Yeah. I mean, generally, in my experience, and you can correct me if I'm wrong, sending letters with a demand typically will help resolve most situations. I think both sides generally want to limit the potential for litigation and expense. So I like to recommend the approach where the lawyers are talking or sending a letter outlining what they believe the breach is. Do you find generally that works as an effective first step, or do you most often see going to litigation as the only viable option?
Well, I highly recommend sending a letter and having some discussions. And sometimes it's better to do those through your counsel as opposed to directly, because counsel can take the emotions out of the situation,
right,
and talk objectively about what the issues are and how much damages you are. But many times you can resolve a dispute before you go to a lawsuit. That's a big step. And, I highly recommend people use all the tools at their disposal to resolve a dispute before they file a lawsuit. And, I can be negotiating a resolution to a dispute. And that involves talking with the other side. Also, if you want assistance in resolving a dispute, you can hire a professional mediator, which is not binding, but they can sit down and you hire somebody that both parties respect, or all the parties respect, that knows something about your business, and they'll help you try to formulate a resolution. And as long as you don't delay that filing a suit so long that you're beyond a statute of limitations where you're prevented from filing, those are very effective ways of resolving disputes that don't involve actual litigation.
What about in an oral contract? How do you prove a breach occurs? You said you're going to send a demand, you said you were going to pay me this, or you said you were going to do that. But if it's oral, can't the other side just say that's not what we agreed to? How does that work?
Well, enforcing oral contracts are very difficult, and but they are enforceable. If you have an oral contract which has not yet been performed, in other words, you haven't engaged in it, it's much harder to enforce. And there's also limitations to oral contracts. For example, in Illinois, there's a statute called the Statute of Frauds, and it's to prevent people from just coming up and saying, you had a contract, you promised to pay me this. And so contracts regarding the sale of real estate are prohibited. For example, contracts regarding a service that takes longer than a year to do are prohibited. And even the sale of goods or selling something more than $500, can't be enforced. And there's other exceptions too, but generally it is enforceable. And what you do is you look at the course of conduct of what the parties have done to show, so if I was going to have a client accuse somebody of breaching an oral contract, I would send them a letter and say, our clients had an agreement to do X, Y, Z. The terms of the contract were the following, and your client failed to perform this aspect of that, and we request that you make it right or pay us damages that were caused by the breach. Now, they can deny that occurred because you don't have a written contract, but it doesn't mean you don't have writings or documents to support it. For example, if you negotiate a contract and you exchange multiple written copies, but at the end of the day, nobody signs it, it's an oral contract because it's not signed. I actually have a case involving a medical institution that they were entered into a contract with another medical provider to share costs and expenses. They had exchanged a written contract multiple times, and then finally the party who was going to receive the services said, "Hey, I like this contract. I'll get it back to you signed next week when somebody comes in town, but we need you to start providing the services right away." And the provider said, "Sure, we'll do that." And they provided services for 18 months without ever having somebody sign the contract because they were sending invoices and they were paying the invoices. And so when they breached the contract, we sued them under that for failure to pay, and we sought attorney's fees. And the only way you can get attorney's fees if you have a written contract, which allows you to receive those, or there's a statute. And in the written contract that was exchanged, it had a provision for attorney's fees, but they took the position that they didn't agree to that there wasn't a writing. And so we ended up, litigating for 8 or 9 months before we got a settlement, which they agreed to pay us everything they owed us plus the attorney's fees.
Wow.
But it could have been much simpler if they'd done the simple thing of just having the contract signed.
Right. And on a separate but related note, physician and provider contracts need to be in writing for compliance purposes. So when you, in particular, are a hospital, for example, and you have a doctor who is referring patients to you or particular services to you, doing that without a written contract may, in addition to all the contract issues you raise, violate federal law. So another reason for everybody listening out there to really make sure you have those written contracts. It seems like there's so many more benefits to having the contract in writing than depending on an oral agreement.
Absolutely. Because there's a lot of things that you would put in an ordinary contract that you wouldn't think about doing in terms of a handshake deal. For example, many professionals prefer to go to arbitration versus court. And if you would put that in the written contract, if it's not in the written contract, you can't enforce that unless both parties agree to it. Another thing is jurisdiction. Where is the lawsuit going to be filed? If you have one party that's in Pennsylvania and one party that's in Illinois, does it get filed in Pennsylvania? Does it get filed in Illinois? Or is it the first person to race to the courthouse? You can address those in a written contract before any dispute arise, while the parties are still trying to make a deal. And that's where those decisions should be made, not after there's breach.
Right. I agree. And in addition to the normal physician stuff, where am I working? When am I working? Those kinds of things that any provider would be interested in. Termination plays a very special role in provider contracts as well. Typically, when I'm negotiating these contracts, if the other side terminates, for example, the practice, the hospital, whatever it is, I try and tie their termination to certain advantages for my client, which might be releasing them from the non-compete or paying the tail policy, maybe not making them repay a signing bonus or forgiving other amounts that might exist. On the alternative, if the provider is the one who breaches, the opposite may be true. They may be responsible for paying a tail. They may have a non-compete. They may have to pay back a signing bonus. So if those are important provisions and those feed into protecting the parties and their business interests, they feed into financial issues in particular. It's so important because I can't even imagine if we had an oral contract, how those would even play out. I mean, I don't think you can enforce an oral non-compete. Certainly the other side would say, you never told me that, right? So you couldn't do it.
You're exact. For the situation you're describing, an oral contract would be unacceptable from a legal standpoint. but it doesn't mean that people don't find themselves in those situations,
Right.
because sometimes people aren't always using best practice. They're using what is expedient or efficient, or maybe it's somebody they've known for a long time, or it's an informal deal that gets put together that they intend to put in writing sometime in the future and just
Right.
don't get around to it. But if one of your clients finds themselves in a situation where they have an oral contract, don't fear. It's still enforceable, except in
Right.
limited circumstances. But clearly, for the regulatory reasons that you addressed, and just the clarity of both sides knowing what the terms of the agreement are, written contracts in the professional world are much better.
That's great. All right. Well, I think, we've given everyone really good insight into understanding oral versus written contracts and some of the things to think about if you want to terminate and you want to enforce. But this is, pretty, intricate in terms of how you actually make these things happen. So obviously, Mike, you're the one that I would come to when my clients got a breach of contract or other type of claim. Are there any final words that you want to share with us on this topic?
One is that in many contracts, written contracts, people have to decide between whether they want to, if they can't resolve the disputes on their own, if they want to go to like arbitration or if they want to have an arbitration provision in their contracts requiring people to go. And I would recommend that for most professionals, especially in the medical industry, because you get to select an arbitrator that is acceptable to both sides, which is somebody who knows your which is a big advantage, rather than taking a random draw at a publicly elected judge that may or may not know about your area,
Right.
or ending up in front of a jury that doesn't know anything about your area. And then also it gets resolved much quicker in an arbitration basis. So when you have a business dispute, the parties can usually afford to pay the arbitrator to get it done. But in general, I would just close with written contracts are good. Good fences make good neighbors. And so you should work out as many details as you can while the parties are still of a like mind to make a deal before, and then in that unfortunate incident where the parties do have a break and they stop wanting to do business together. And then, contracts are really only worth what you're willing to pay to enforce them, because they're not the force of law. They're not, the marshals won't come out and enforce your contracts. You have to go to a civil judge and seek money justice for the breaches. So I think those would be the closing thoughts I have on just the general outline of contracts.
Great. Well, thanks. This is Mike Scotti, shareholder at Roetzel & Andrus and head of our litigation group. I'm Ericka Adler from Roetzel & Andrus as well, and this has been the HealthLaw HotSpot. So if you'd like to see some more of our podcasts, you can check us out at ralaw.com, and we will see you next time. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.